Hey out there, legal warriors. Did you know there's something called the 4-hour rule that leads to a whole ton of unwanted arrests by the people that called the police to try to get a dispute at home settled when they really don't want anyone arrested? They may not even feel a crime's been committed. If you're interested in that 4-hour rule and how to deal with it and how it works and how to protect yourself from it, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years and putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get the help they need. Now I'm just going to jump right into it. So the 4-hour rule applies to domestic violence cases. And before you just click off this video and say, that would never be me, I don't do domestic violence, remember that anybody can get accused of a domestic violence crime because it involves human relations between people that are family or household members or intimate partners. And pretty much all of us live with somebody or have lived with somebody, have dated somebody, and we've all got family members. And things happen where there could be a dispute, and let's hope no one ever calls the police. But what happens in Washington State so much, especially with people from different cultures and backgrounds, is there'll be a dispute at home, and somebody will call the police because they just want to calm down, right? They don't want somebody arrested. They don't want any type of criminal charges pressed. But the police show up and they end up hauling somebody away, even though that's not what the caller ever imagined happening. That's not what the caller wanted in these examples, right? Sometimes they do, but not in this example. It happens all the time, and it's really traumatic for everybody. And I'm not making an excuse for domestic violence. That's not what this video is about. It's informing you as a member of the public that this 4-hour rule exists. So tell me more, Lance. Okay, so there's a statute, a law, RCW 10.31.100, that deals with the authority of officers to arrest. It's a pretty long statute, but if you go down it a ways, part of the statute says an officer shall arrest in certain situations. So that means they don't have discretion. And they shall arrest in a case of domestic violence if there's been harm, threat of harm, physical touching, that type of stuff. And they have to arrest if any of that stuff happened within 4 hours of the time that officer knocks on the door. Okay? And if it's outside of 4 hours, now the officer can use discretion. But within 4 hours, they can't use discretion. And so where do we see this happen? Give me a hypothetical, Lance. Okay, the one we see all the time is there's a dispute at home. Oftentimes, you might be from another culture. I've had plenty of clients from other cultures, China, India, a few others, where in those countries, if you were to call the police, I'm told by my clients that the family police would show up just to try to settle the dispute, right? In some of those places, disputes that involve a little, a shove or this or that, which we should not do, it's illegal in this state, are more common. So they don't expect anyone to get arrested. And what happens is the officer shows up and somebody has to get arrested because someone says I was pushed, or they threw a plate at me, or they broke this or broke that. And the caller never intended that to happen. So we have to know that that 4-hour rule takes away the discretion of the police officer. They've got to make a custodial arrest. That means somebody's actually going to jail and they're not getting out. There will be no bail. Because the law also says in domestic violence cases that bail can't be considered until the judge has an opportunity to issue a no contact order, ordering the defendant to not have contact with whoever the alleged victim is. And how do we know who the alleged victim is? Is the alleged victim always the person who called the police? No. At least 4 times this month, I've had clients in my office. They were the ones that called the police for all types of different reasons, some not even dealing with an assault, some just to get back in their own home. And even though they called the police, somehow the other person trying to protect themselves, or who knows, just making stuff up, claims something happened to them, and the officer arrests the person calling the police. So, if we're a victim of domestic violence, we need to call the police and we need to protect ourselves. But if we've just got some type of dispute going on, you need to at least know this is what is going to happen so you can make an informed decision about what's best for you, because the state's going to take away your right to decide, right? In this state, you do not have to press charges for the state or the city or the government to file a charge against someone. It's not up to you. If that officer thinks there's been a crime and it's a domestic violence crime involving family or household members or intimate partners, they've got to arrest. They have to. And so you don't have a choice if you're the supposed alleged victim in the eyes of the government. So I want you to know this exists. I'm not encouraging you not to call the police, but I think it's heartbreaking how many calls I get. I'll probably get 2 or 3 this weekend about a spouse saying, I never wanted this to happen. They're in jail. They're going to lose their job. We're going to get deported, whatever it might be. And it's really tragic. It's an unintended consequence probably of all the years, decades ago when officers weren't making arrests that should have been made. And so we all have our own opinion. I'm just trying to make sure that you know this exists. So what do you do about it? Right? Lance, thank you for telling me it exists. Now, what do we do about it? Well, one thing you can do to avoid this 4-hour rule is leave, right? If your partner's going to call the police, you can leave. If they don't find you within 4 hours, they can't arrest you, right? And then once the 4 hours mandatory is gone, then it's probably just going to go to the prosecutor and you're not going to get arrested. And there's going to be a better chance for things to work out. What else can you do also? Well, if you're the one calling the police and you don't want somebody arrested, you want to calm down, well, you probably don't want to be volunteering that there is a push or a shove or stuff like that. You can't lie to the police, but you could still think about what you're going to say, and maybe you don't want to exaggerate, right? What happened as well. So it's important that we do be careful with what we tell the police. And so those are the 2 main things I think that we could do. We can leave and we can be careful about what we say, because officers coming to the scene of a DV call, they're programmed to make an arrest, right? They're instructed that they have to, right? If they believe there's been a crime. And let's then go to the final thing to talk about here is how do they decide who to arrest, right? The law says they need to arrest the primary aggressor if both people have technically committed an assault. If both have shoved or pushed or hit or spit or thrown drinks or Lego or whatever, it's very broad, the definition of assault. Now the officer is supposed to arrest the primary aggressor. And while who took the first act is a factor in the statute, it's not the only factor. One of the factors that shall be considered is who has the worst injuries. So the other person starts it, you respond, you've got fingernails and you scratch your boyfriend, even though he started it, he's got the scratch. That leads to you getting arrested because you got the fingernails and there's scratches on him. They're also supposed to look at a history of domestic violence, but often there isn't one. Often there isn't a verifiable history that they can see through arrests. If there's prior arrests, they're supposed to consider that as well. But generally it comes down to the person with the worst injuries is turned into the victim, and the person with less injuries is turned into the defendant and gets hauled away if both people allege touching. And usually both people do. Sometimes one person keeps quiet about it, trying to protect the other, and the other person says, no, I was pushed. Well, the one keeping quiet then gets arrested. So it's pretty much a landmine walking in through the situation. So it's, it's best we never get in these situations. And again, I'm not at all condoning any type of DV, but I do think it's important we know what the law says, because so many times people end up with charges being filed they never wanted. And they think, well, if I don't press charges, it's not going to happen. That's not true. Criminal cases are not victim versus defendant. It's state of Washington versus defendant, or city of Linwood versus defendant. And the only rights you have as a victim is a right to some notifications about things. You don't have a right to have the no contact order dropped. You don't have the right to dismiss the case. You are subject to the way the system wants to think about your life, no matter how you think about your life. And as you could tell, at times that upsets me. So I hope you found this useful. If so, please like and please subscribe. More people get the help they need. More importantly, if you're dealing with a DV situation, any type of criminal situation, victim or defendant, feel free to give my office a call. Listen to what happened. We'll identify a way forward. We will be there for you. Thank you.